Welcome back to the Hearst Chaser podcast show. This episode is all about trust issues. No, not the relationship kind. In this episode, we're going to break down the differences between revocable and irrevocable trust. What I mean by that is we're going to talk about how they're similar. We're going to talk about how they're different. And importantly, the factors that go into determining which one is the right one for you. We're glad you're here. Welcome to the Hearst Chaser podcast show.
You're listening to the Hearst Chaser podcast show. Here's your host, Stephen McClellan.
All right, welcome back. We're talking about trust issues. We're talking about estate planning on a deeper level. And the purpose of this podcast was really a question that comes up a lot in my practice is, how do I know which trust to choose from? And a lot of times what you'll find is some estate planning attorneys just do wills. That's all they do. And it's sort of like, sometimes there are financial advisors or they sell products, they sell annuities. That's all they sell. So if you're a hammer, everything looks like a nail. And so the point of this is to think beyond wills, to think about trust, which generally speaking, I think trust accomplish a lot more goals that clients have. They are more complex, and yes, they require more work. But generally speaking, trust are a fantastic tool to transfer assets from one generation to the next. So a lot of folks don't do irrevocable trust, or they don't understand them, or perhaps they are uncomfortable with them. So we're going to break that down in this podcast. So let's talk about just what is a trust first before we talk about the similarities. The idea of a trust is a document that is created by a grantor. Grantors are the ones who set up a trust. And the main difference between revocable and irrevocable is kind of what the goals are in when we are concerned about the end. Okay, what are we trying to accomplish? But both of them are set up before you die. Generally, they're set up by you. They potentially could be set up by a power of attorney, but in 99% of the time, you're setting them up. And so instead of assets going to probate when you die, instead of assets going directly to beneficiaries when you die, those assets go into a trust. And you can see all kinds of different names, living trust, revocable trust, those names mean the same. But they're both legal entities. They have requirements on how they have to be set up. They are not simple. Okay, I see a lot of advertisements for, hey, your estate plan is simple. You can do it in 30 minutes. And I've met with thousands of people, and no, I don't think 30 minutes is an appropriate amount of time to really come to the pros and cons of the estate plan and all that's involved in it. Trust especially has a lot more complexity to it. So the key to a trust, the thing that makes it difficult, whether it's revocable or irrevocable, is you got to make sure that the assets go into a trust. What do I mean by that? The term of art here is called funding. Funding is connecting your assets to the trust. And here's where all the corners are cut. Here's where all the mistakes occur. Here's where all the complexity is. And it's all about funding, making sure things are set up. A lot of people think that when they sign a trust instrument, the day they come in, they sign a trust instrument, they're done. That's kind of the way a will is. You sign a will and you're done. I mean, I could do a will in 20 minutes or so, but when you die, that will is probated, and you're sitting in probate court for maybe a year, costing thousands of dollars. And so while the price of a will in time and money is very small, okay, the cost to the family and the time and the effort is a lot. When you're doing a trust, the price to you, the grantor, the client, is more. You're going to pay more for a trust. You're going to have to do more work. But the idea is that if mom and dad do some work, it's going to save a whole lot of money and a whole lot of time for the kids. And that's really the driving factor, I think, when it comes to doing a trust, that it's meant to save time, it's meant to save money, and keep things out of court. Okay, I jokingly say I would love to put probate lawyers out of business by doing a ton of trust and there is no probate. Now, that will never actually happen because probate attorneys do a lot of things like guardianships for minors and guardianships for adults, and you're not going to get everybody to do an estate plan or to do a trust. Some people just don't get around to it. So what you need to know is that whether you're doing a revocable or irrevocable, there's this idea that you need to make sure assets are connected to it. And that's the secret sauce. That's the thing that we emphasize so much in our practice, having someone dedicated to walk you through that. And what, in my opinion, it has gotten more and more complex setting up trust because our clients have assets everywhere. It is so easy these days to set up an account online or to set up a retirement plan, and you may have multiple retirement plans and multiple life insurance policies and everything scattered, and each one of them has to be contemplated when you have a trust. And the reason, if you don't fund it, okay, first, it may not go where you want it to. Second, it may go to probate, cost you money. And third, if it doesn't go into the trust, it's not going to have the protections that you need. So if everything goes into those trusts and you have a design for how things go, it's going to be consistent. So another similarity is revocable, irrevocable. It's going to have a plan for how things go. And good estate planning, good trust work is going to have a lot of contingencies. So yeah, I know most people say if husband dies, they want everything to go to wife. If wife dies, everything goes to husband. When they both die, they want it to go to kids. But a good estate planning attorney is going to think, well, what ifs? And so a trust is really designed for all those what ifs. Well, if my child dies, I want that money to go to grandkids. And maybe that grandkid does not receive that money at 18. That would be a very, very bad thing. Maybe they should wait until they're 25 or 26 or 30. And so the element of trust is that you can give the money to people when they are responsible enough, okay? We all agree, if you give an 18-year-old $20,000 or $40,000, they will think they never have to work the rest of their life. It's their mindset. And it's really hard. If they take that year off, they've been going to school for, since they were 6, and they take that year off, it's really hard to get back in that rhythm. That's my thought about money. I don't think they should get it at 18 because they really need to get with their peers, get into school, keep going. So that's what a trust can do. Both trusts are created during your lifetime, okay? So you may have heard the term inter vivos. That just means while you're alive. I don't use the term living trust to refer to our revocable trust. I'd rather say it's revocable, meaning you can make any changes to it. I don't need to say it's inter vivos. It was made during your lifetime. I don't do that. Now, I want to caution you here because in some cases, the trust may be set up as a testamentary trust. This is a very different thing, okay? Caution, red flags here. That is a last will and testament that creates a trust. I saw more of those from the 90s, late 2000s. Most people don't do that. Now, there are pockets of attorneys and areas that they do a lot of that. Okay? I don't like that. That requires the assets to go through probate and then set up a trust. And, again, if the assets are stuck in probate, that's time, that's money. And so you might ask, well, why would someone do a testamentary trust? I'm sure those lawyers can justify it. I don't think that fits what clients are willing to do that funding, set it up before they die. Yes, it is more money to do that work, but you're saving so much time. There's no reason. I can't say there's no reason. I just think testamentary trusts just eat up a lot of time and money and cost, and that's really not what clients want. But I just want you to know, a will that sets up a trust is not what we're talking about here. We're talking about a trust where assets go and avoid probate. Any asset can go into a trust. You can have real estate. That's very common, like home, land, lots, timeshares, lake houses. We put any kind of real estate in there. Bank accounts, checking, savings, investments, stocks, mineral rights, business entities. All those things can be inside of a trust. There's really no limit to what you put in there. It's important that in both trusts that you have a backup. So generally you have somebody who's in charge of that trust. In the revocable trust, it's typically you. On an irrevocable trust, it's somebody else, generally speaking. But you want to have backups. So, maybe your oldest kid is the one that you want in charge, but you can have as many backups as you want. There's an element of privacy. Both of them avoid probate, and they're not subject to public records, which is nice. Also, they can be used for incapacity planning. So if you instead of your assets going in a guardianship, they can go into a trust, and that keeps it out of the court as well. Both have detailed distributions, and both can say the same thing generally about who gets what, when they get it, how they get it, if there's any restrictions on those funds. Here is the big one. Both of them can have language that protects the assets if kids are being sued or filing for bankruptcy. And you just never know what the future can have, so both trusts are a little bit of insurance against kids doing things that they shouldn't do. Both trusts, whenever we do a trust, I want you to know we also do a will. So a will, it's called a pour-over will. It says if you left something out, the will says put it into the trust. Yeah, that still requires probate. It does kind of speed up that process, but there is always kind of a will with a trust. It's funny, everything I'm telling you, I'm telling you the right way to do it. I've seen so many do-it-yourselfers, so many folks have tried to do it themselves, leave out some of these things. And I'm just thinking of all the headaches that if you had a trust but not a pour-over will, that's happened in this scenario, then those assets that were left out of the trust would go to the family. It wouldn't necessarily go to the trust. It could be different beneficiaries. Your will, or if you don't have a will, intestate laws typically say things go to your spouse and kids. But if your trust says, I want everything to go to my oldest kid, there's really inconsistency. So I've seen that happen before. And I've seen people do trust online and not fund it at all, which is basically a waste of paper. Like if you say, hey, I want all these assets in this trust to go to the Ronald McDonald House, and there is nothing in that trust, then the Ronald McDonald House gets nothing. Both of them have some tax planning. They can have life insurance policies, those kind of things.
Thank you for tuning in to the Hearst Chaser podcast show. Our mission is to be your first choice for last wishes. Want to dive deeper? Join us over at the Hearst Chaser Academy, where we've created 8 on-demand courses for each stage of life. From young adulthood to retirement, navigating separation or blended families, and everything in between, we help you plan for the future, no matter where you're at. Now stay with us as the ride continues on the Hearst Chaser podcast show.
Amendability. Can you change it? Revocable trust, yeah, you can change it all day long. In most cases, you have to be cautious if two grantors set up a trust. This is nitpicky here. But when you have a husband and wife that sets up a trust, you have to ask the question, well, what can my survivor do? Because I've read some trusts that prevent the surviving spouse from making changes. Okay? That's a mess. My opinion, y'all been married 30, 40 years. You can do whatever you want to. My wife, it's hers. She can do whatever she wants to. She remarries. It doesn't really bother me. She can make any changes she wants to. Now, that's not always true, so you got to be cautious. I don't want to say revocable trusts are always amendable because there's certain circumstances they're not. Irrevocable trusts, same deal. Often there's more restrictions on the irrevocable trust. Oftentimes we want to refer to those irrevocable trusts as not changeable. That's not 100% true. Kind of depends how you draft it, but amending is a question that needs to be addressed when you draft the documents and talk about the pros and cons of both. Lastly, with either trust, you can address blended families, special needs planning. Every trust that we do has special needs language in it in case somebody has a traumatic brain injury. We plan for that to protect assets. And maybe nobody in your family is disabled, but a special needs trust is always there to protect those assets. And some medical conditions, like bipolar disorder, some of that doesn't get diagnosed until late 20s. So sometimes we really just don't know. But trusts are great, whether it's revocable and irrevocable, all those things that we can do. Getting down to the big key differences, okay? This is where we sit down with clients and we're trying to figure out what are we trying to accomplish. Primarily, the number one reason clients come to our firm is that we are an estate planning and elder law firm. And elder law is really how do you protect assets from the nursing home. And irrevocable trusts are one way to do that. There's two types of asset protection. There's proactive planning. Proactive is you're doing something before you get sick. And then there's crisis planning. So I'm not going to talk about the crisis planning. There's still things we can do from an asset protection standpoint, even if you don't do anything. But a lot of folks come to us and say, hey, we want to protect our assets from our nursing home. So here's a couple thoughts. The revocable trust doesn't have protection because you can put assets in a revocable trust, you can take assets out, you can make changes. So as far as DHS is concerned, you have control over that. It's your asset. So that's a big one. And number two, the irrevocable trust has to be set up 5 years before you go into a nursing home. Okay, so I'm about to tell you some really good stuff here. The average person goes into a nursing home at 79. So if you have to do it 5 years before, 79 minus 5, 74. Okay? Let me say it a different way. You can't do an irrevocable trust on a Friday and then go into a nursing home on Monday and say, I have no assets. It doesn't work that way. But I think it's important to know the averages. Now, I've had and seen clients, family members who started having dementia in their 50s. Well, if that's the case, we might want to do an irrevocable trust way earlier than that. But generally speaking, most of my clients, they are first-time estate planning clients in their 60s. That's average. They've put it off. They've never done it. And they finally said, okay, now we've got some time. Let's go talk to the attorney. And so they've never really thought about it. And so the thing about 60s is very different than 70s. 60-year-olds, they typically don't want to think about the nursing home. But 70-year-olds have a very different perspective. I see it all the time in my office. 70-year-olds are like, yeah, I've seen people get sick. I've seen the strokes. I've seen the heart attacks. Yeah, it's very real. 60s, your retirement, you're thinking about all the years, things that you can do, but something happens in your 70s. So I think most of my clients who are in their early 70s, that's the best time to think about it. I've done irrevocable trust for clients in their 80s because they were in great health. and it was very likely that they could make it 5 years. Okay? So the irrevocable trust is really putting assets aside and putting somebody in charge of those assets. Okay? And that trust is going to have language that the principal and income, kind of depends on what it says, but a lot of times you'll say the principal and income is for my lifetime beneficiaries of my kids. Okay? Sometimes the trust will say you still have a right to stay in your home, but the idea is that it's kind of out of your name and you're putting somebody in charge. So a couple things here. If you don't have anybody you trust to manage it, that's kind of a concern. So it might be that when people talk about asset protection, they're thinking they want to protect the assets for their kids. Well, it might be true that your kids just aren't the ones that you want to protect. You don't have anybody that you want to protect it. And if that's the case, then we're not really worried about an irrevocable trust. It may also be that you just don't have anybody that you trust. Sometimes we'll call them like a family asset protection trust, because there's this element that you need to have a family member, a person that you trust. Perhaps the question might be, well, what's the downside of doing an irrevocable trust versus a revocable trust? Well, typically your irrevocable trusts are going to be a little bit more money-wise. It's hard to say how much. It depends from attorney to attorney, but you might have to pay $500 to $1,500 more, somewhere in that range. It's more complex because you're bringing children in. They have documents to sign. The question might be, well, what happens if I die in 2 years and I never go into a nursing home? It's not a problem. Well, that sounds terrible. I mean, I know you've passed. I know you're gone. But everything is going to be distributed the same way it would under a revocable trust. That is, to your kids, if they die, to the grandkids. So everyone tells me, I don't want to go into a nursing home. Everybody tells me that. Is that, oh, my kids will take care of me. Well, we don't really know, right? We don't know what's going to happen. Like if you have a stroke and you're a 2-person assist, your spouse might not be able to lift you. If you have dementia, you're not the same person you were 10, 15 years ago. And I've seen where spouses call the cops and say, who is this strange person in the house? I've seen those things. My frustrating thing as an attorney is that a lot of folks who they do webinars or they do advertisements, they throw out this number. Over 70% of Americans will need long-term care services. I don't like that number because I think it scares people into making a decision that you got to protect from the nursing home. Because it's not everybody. It's not 70% of people need long-term care services in a nursing home. That statistic is about assisted living. It's about if you have rehab for a knee replacement, in-home care. It covers a lot of different things. I think the better statistic, the better number that's, I think, fairer is somewhere around 16 to 20-something%. Okay, not 70. Less than half of what they're saying are people who actually need long-term care services in a nursing home for a long period of time. That's what the concern is. So it's a good deal. It's a great deal if you can protect assets, because I get it. Nursing homes are $8,000 a month. It's a little more than that, and there are some in Arkansas that are $10,000, but you're talking like $90,000 a year. And obviously, I think if you have 1.5 million, 2 million, you're probably self-insured. So if you're watching this, I probably should have said this at the beginning. Hey, if you have 2, 3 million, you probably don't need irrevocable trust. You probably have enough as it is. There's also another consideration that if you have a irrevocable trusts are great if a bulk of your estate is in real estate. So if the majority of your assets, it's your home or farmland, love irrevocable trust. It's a little bit different when it comes to retirement accounts. So if you got $500,000 in an irrevocable trust, $500,000 in an IRA, $500,000 IRA, probably not a good idea to put that in an irrevocable trust because you're going to have to pay taxes to get that into the trust. I think that's a little aggressive. $500,000 doesn't mean you put $500,000 in the irrevocable trust. That reduces, if it's 20%, you're down to $400,000. You gave Uncle Sam $100,000. I mean, there's pros and cons. We can talk about that. I mean, again, the health, I think, matters. Like if someone has Parkinson's or someone has early onset dementia, maybe we would, even though there is a tax hit. Now, there's a very high probability that someone may need a nursing home for a long period of time. So I don't think it is simple. I don't think it's easy. I don't think there's no hassle. It's complicated, and that's why a lot of times we're looking at the health of the clients. We're looking at how much there are in assets. We're looking at what type of assets, and we're looking at the family dynamics. So if you have 3 daughters like I do, high probability someone's going to take care of you. And so there's a lot of different factors that go into it. And just knowing the statistics, not everybody, that 70% number that's thrown out way too much is a scare tactic. But there is benefits of an irrevocable trust versus a revocable trust. But generally, 60-year-olds don't do irrevocable trust. They'll convert it later in their 70s, but generally when they're in their 60s, they don't do that. So hopefully this helps. There's so many things I didn't even mention. Something about the irrevocable trust is nice because it kind of locks in the distribution, so it doesn't change. That's kind of nice. So the family knows what they're going to get. Irrevocable trusts do have some, asset protection, from lawsuits. That's another thing as well. I'm not so worried about that with our clients that get older. They're not doing very risky things. They're not driving a whole lot. So I'm not so worried about that. That could be an issue. I'm more worried about elder abuse that can happen. So if I have these funds, because you can put cash in an irrevocable trust, CDs. Well, if it's in an irrevocable trust, I don't have to worry about someone scamming mom or dad. So that is a positive there. So hopefully this kind of helps. It's not a replacement for talking to an attorney and going through the analysis as it relates to, the unique circumstances for you. But if you want to know more, I know we already kind of mentioned it in our ad, but in the Hearst Chaser podcast, at Hearst Chaser Academy, we have a stage solely dedicated to crisis planning. So everything we've talked about here is trying to do something before 79, but if you don't, mom or dad is 79 and they've never done anything, or 80 and they're going into a nursing home, that's what the Academy is all about, because it kind of walks you through some of the crisis planning that even if you don't do this, there are still ways to protect assets. So it's not all lost if you didn't do an irrevocable trust, and that gives families a whole lot of relief and comfort knowing that. So went a little bit longer on this podcast. I hope you understand it's a little bit more complex when you're talking about trust issues, right? That's a difficult topic. So hopefully it's helped you make some decisions, and if we ever can help you, a family member, kind of work through those, don't ever hesitate to reach out to us. Enjoy your ride today, and thanks for joining us on the Hearst Chaser podcast show.
Hey, thanks for listening to the Hearst Chaser podcast show. Please remember, you can't outrun a hearse, but you can leave your family with a smooth ride.